Fraud in the inducement is a serious legal issue in California that can void contracts and lead to significant damages. It occurs when someone is tricked into signing a contract through false representations or promises. Understanding this concept is crucial whether you're entering business agreements, employment contracts, or real estate transactions. Under California law, fraudulent inducement happens when one party deliberately misleads another to get them to enter a contract. This type of fraud can make the entire agreement voidable and serve as a defense against breach of contract claims. To prove fraud in the inducement in California, 5 key elements must be established. First, there must be a material misrepresentation of fact. Second, the person making the representation must know it's false. Third, they must intend for the other party to rely on this false information. Fourth, the victim must actually rely on the misrepresentation. And fifth, this reliance must cause harm or damages. It's important to distinguish between fraud in the inducement and fraud in the factum. Fraud in the inducement involves being tricked into signing a contract through false promises or omitted facts. The contract itself is what you think it is, but you were deceived about important aspects. Fraud in the factum, however, means being misled about the very nature of the document you're signing, such as thinking you're signing a lease when it's actually a deed. California courts treat these differently. Fraud in the factum may render a contract completely void because there was no meeting of the minds. Fraud in the inducement makes a contract voidable, meaning the defrauded party can choose to rescind it. Proving fraudulent inducement in California courts requires presenting specific facts, not just general allegations. Plaintiffs must show exactly who said what, when it was said, and why the statements were false. Helpful evidence includes written communications showing deceptive promises, witness testimony, evidence of similar conduct by the defendant in past dealings, and discrepancies between oral promises and the final written contract. Intent to deceive is a critical element. Some evidence must verify that one party was intentionally looking to deceive the other. Simply feeling or believing you were deceived is generally not enough to prove fraud in court. Fraudulent inducement commonly occurs in several scenarios in California. In business transactions, it might involve misrepresenting financials or client lists to induce a sale. Employment offers may include false promises about roles, compensation, or bonuses. Real estate transactions can involve false claims about property conditions or zoning compliance. Franchise agreements might include misleading revenue projections, and settlement negotiations could involve offering terms under false pretenses. If you've been fraudulently induced into signing a contract, California law provides several remedies. You may seek rescission, which undoes the contract and restores both parties to their original positions. You can pursue damages to recover financial losses caused by the fraud. You might also ask for declaratory relief, where the court declares the contract invalid. In cases where oppression, fraud, or malice can be demonstrated, punitive damages may also be awarded. It's worth noting that fraud in the inducement is distinct from breach of contract, though they can sometimes overlap. Breach of contract occurs when a party fails to fulfill their contractual obligations, but no ill intent needs to exist. Fraud, on the other hand, involves deliberate deception with the intent to cause harm. Fraud in the inducement also serves as a powerful defense to breach of contract claims in California. If you can prove you were fraudulently induced to enter a contract, that contract may be considered voidable, making any claimed breach legally unenforceable. California courts evaluate whether reliance was reasonable based on the sophistication of the parties and any disclaimers within the contract. Importantly, even a written contract with an integration clause does not automatically shield a party from fraud claims. If the fraud occurred before signing, the claim may still succeed despite what's written in the agreement. Understanding fraud in the inducement is essential for anyone entering contracts in California. If you believe you've been a victim of fraudulent inducement, it's advisable to consult with a qualified attorney who can evaluate your specific situation and advise on the best course of action.